Hello, everyone. Welcome back to On the Ground. My name is Benjamin King, CEO of Kinyu Supply Chain Management. We're a supply chain focused employer of record here on the ground in Guangzhou, China. So today I have Daisy Yang, attorney at law from Beijing Yingke Law Firm, who has come to our office here in Guangzhou. You've come up from Shenzhen. Thank you very much, Daisy, for joining us. Today, we're going to talk all about termination of employment contracts here on the ground in China. We cover all range of termination, illegal termination, legal termination, mutual consent. We talk about how you need to take the emotions out of your termination procedure. We talk documentation. So tune in and let's start the show.
Thank you so much for having me, Ben. Should I introduce myself?
Yeah. Give an intro.
As Ben mentioned, I'm an attorney at law from Beijing Yingke Law Firm. Yingke Law Firm is one of the largest law firms in China and also in the globe. We have more than 20,000 lawyers in the world. And in Shenzhen, I'm based in Shenzhen office. We have 1,200 lawyers, and I'm focused on corporate governance, company compliance, and labor law.
Yeah. So, we were just talking earlier. There's the largest law firm in the world, 20,000 lawyers, but it sort of almost acts as a platform of lawyers, and you are almost like your own individual practice.
Exactly.
Under the umbrella of Yingke, right?
Yes, exactly. This is a little bit different from what the Western world law firm works. So in China, most of the law firms are more like a platform, or we can call it franchise, that each individual lawyer or each individual team is responsible for their own clients, for their own portfolio. For instance, I'm now working with another team, another colleague. We are focused on international affairs for international clients, Chinese clients going to abroad, or foreign clients coming to China, as well as data privacy. In our team, we only have six people, including me. But before that, I was individual lawyer. I was responsible just for my own clients, and I didn't have a boss.
Yeah. Oh, fantastic. So today we are going to talk about termination of labor contracts in China. This is a meaty topic. There's a lot to go through. We might block this into small episodes, and definitely you can search through, look at different aspects of termination that we're going to talk about. So strap in and make sure that you watch all the bits that might be relevant for your business. So Daisy, first of all, you mentioned before the majority of your clients are foreign clients.
Yes,
So
exactly.
do you want to just go through the different types of termination, and then also what are the types of the most common cases that foreign firms are facing?
Yeah, definitely. So in general, there are three types of termination under Chinese labor law or Chinese labor contract law. The first one is the mutual agreement. Mutual agreement meaning both the employer and the employee reach an agreement to terminate this contract. The other one is unilateral termination. It can be initiated by the employee or initiated by the employer, by the company. And the third one is automatic termination. In Chinese, we have a different word for this automatic termination. It's called 终止, which means reaching certain circumstances, this agreement is just terminated without for this termination that we were talking about earlier. In Chinese we call it 解除. 解除 means we are terminating this earlier than it's supposed to be terminated. But for this 终止 means there are certain circumstances, such as the contract has expired, or the other one is when the employee reaches the retirement age, then we call it 终止. It's not 解除 anymore. So there are, I would say, 3 types: mutual consent or mutual agreement, unilateral termination, and the other one is automatic termination.
Okay. Just so I know that underneath these 3 types, there are
That sounds easy, right?
Yeah, that sounds easy,
Yes.
right? But there are lots of subtopics under these.
Yes.
Just quickly on the unilateral, I think later we'll get to the unilateral termination from the company, but from the employee. I mean, if they resign, would that be a unilateral termination? It resigns from their place, so they're actually unilaterally terminating contracts.
Yes. Resigning is indeed a unilateral termination initiated by the employee. In most of the circumstances, the company would think this would not cause any compensation or cause any severance pay, but this is not entirely correct.
Okay, so what cases, if the employee resigns on their own back, would they, I guess, does that also include resigning because they feel like there's been a breach of contract from the company side?
Exactly.
And that's where the severance comes in.
Yes, exactly. So there are also 2 types of resignation initiated by the employee. One is probably the employee gets another job, finds a better opportunity, or has some personal reasons, doesn't want to continue to work for this company anymore. This way, they need 30 days notice to be given to the company. Then there's no compensation whatsoever. The employee can leave after 30 days or 3 days in probation. But the other scenario is when we call it the employee is forced to terminate this contract or forced to resign when there's fault from the company side. Very common one is when there are 2 very common scenarios. Number 1 is when the employee claims that the company has not been paying in full the salary or overtime fee or what kind of any kind of monetary compensation. This is number 1. The other scenario is also very common, which is the Social Security. As you know, the Social Security is mandatory in China, but there's historical reasons that not every company was paying or not paying in full from the beginning. So this is also causing termination. We call it forced termination by the employee, and this would also cause compensation by the company. For the security, though, it's very complicated because there were different practices, different cases in the past where the company was not required to pay at all because Social Security can be also governed out of arbitration or court jurisdiction. We'll go there next.
Yeah, we'll get in there later.
Complicated.
So I mean, one key takeaway from that is just because someone resigns does not mean that the company will not face any severance or any consequences. And one thing that we always do, and we always tell people to do, is you have to have an exit interview. You have to understand why people are resigning. I mean, I guess if they're not paying the salary on time or they're not paying it in full, then it's not for its reason. But the employees will resign, and then they will bring that case. Yes. So we've gone through unilateral termination from the employee side, but how about unilateral termination on the company side? So what reasons and what grounds would a company unilaterally terminate the contract?
Yeah, there is also possible for the company to terminate the agreement unilaterally, of course, but they are very much limited when you think about the compensation. In general, when the employees are in fault, supposedly the company should not pay severance pay. For instance, when the employee has breached the company policy or employee handbook materially, or the employee has fault. In general, we call it when the employee has fault, then the employer is not required to pay severance fee. But in reality, this is very tricky because in order to not pay the severance fee, you need to also have not only the ground but also procedural requirements to be met. If you have the legal basis to terminate, but you don't follow the procedural requirements, it's still going to be deemed as illegal termination. So this is the tricky one. Even if the employee is in fault, for the company, you still need to be very extremely careful before you actually send this notification of termination.
So let's dive into that. And let's say we're talking about, breaching the employee handbook. We'll set aside performance later. So not talking about performers, but maybe talking about, a disciplinary. When you mentioned procedure, what do you mean by that? Is that procedure from a labor law point of view, or is that actually from our employer handbook?
There are two layers. Both are required. First of all is the procedure of the employee handbook. Within the employee handbook, you also need to have these procedural requirements. What kind of behavior constitutes the breach of employee handbook, and how many times will trigger what kind of punishment.
Yeah.
And secondly, also how the employee handbook was passed.
Pass, what do you mean?
I mean, if you have everyone's signature acceptance of the employee handbook, that's not enough by the employee labor contract law. You need to have this democratic procedure to pass this employee handbook, which we call it the validation procedure.
So let's just quickly answer that. You get one signature, and then it has to go through a democratic process where everyone together reviews it.
It should be done before. So when you draft this employee handbook, you need to have this, we call it democratic procedure to validate this employee handbook.
Okay.
For factories, for instance, they have trade union. Trade union is very helpful and useful in many procedural requirements. This handbook has to be passed by the union, or not. It's not the pass meaning voting. You need to inform the trade union that you are. The union that you need to inform them you are going to pass this employee handbook, and you need to, if the company doesn't have union, because union is quite uncommon in small SMEs.
Yeah.
So if you don't have this union, at least you need to inform the employee representatives or the whole. For example, if the company only has 10 people, then you need to inform everyone, call a meeting, and you need to have these meeting minutes that everyone was present. We were discussing about this content of the employee handbook, and you collect feedback from every employee. Of course, you don't need to agree with every comment that the employee raised.
Yeah.
You can still pass this, but you have to have this record.
You have to have the record of having
collecting comments, calling for meeting to discuss, and also the training after collecting all the opinion from the employees. Then you have the second draft, and then probably it's going to also be the final draft. Then you need to public the final version, and then conduct training to the employees to give them the training on the content of the employee handbook. Okay. And then everyone has to sign to acknowledge they have accepted the employee handbook. Only after this procedure, the employee handbook will be seen as legally passed.
Okay. So, but what happens if you start with 2 or 3 people, but then you grow to 10 or 20 people? Do you have to maybe do this in regular intervals? Or?
So what my advice is, from the very beginning, you have a very comprehensive employee handbook in place. When you have only 2 or 3 people, you call this small meeting is much easier than when you have 100 people. So from the very beginning, you have this procedure in place, and you validate this employee handbook. As you grow, if you don't change the major contents of the employee handbook, it's already valid. And then when you have new employee, you just need to, of course, give them the notice, the notification of the employee handbook, and ask them to accept, to sign the notice. Then that's already enough. But if you didn't have this very first place, the procedure right, then it's not legal, and you cannot use this employee handbook to terminate any employee's contract.
Okay, well, let's move on. So that's the procedure about the handbook, which is less about the actual incident, but that's something that needs to be done in the background.
Yes.
So then, yeah, and of course, like in the handbook, there can be different stages. So, for example, maybe turning up late has to be 3 times, but you can also have more serious, like for example, it could be sort of damage to company property, or it could be working under the influence of alcohol or drugs or things like that, or breaking the law that are much more serious. But so obviously those are in the handbook, but then how about sort of collecting evidence or that kind of side? So yes, that's in the handbook. Okay, great. Someone has done something which which can be a termination, but then what does the evidence look like? Does it have to be filmed? What is like possible as evidence to terminate?
The strongest evidence would be documentation. Documentation meaning not only the breach of the employee handbook, but also the investigation and also the interview that you speak with the employee. Every step has to be documented, and if you don't do this, it's going to be, for instance, if you find some employee breaching this employee handbook and you terminate immediately without having any written document telling him or her what he has done, and which article of the employee handbook has been breached, and what actions has the company tried to fix. And if there's no documentation to prove this termination is based on breach of employee handbook, this also will be very costly for the company.
Yeah, and I think one huge piece of advice from this, from our conversations in general, is when it's a unilateral termination, it's likely to be something quite serious, and there are going to be emotions involved. But the thing is when you are going, you have to explain the unilateral termination, which means that first of all, you have to collect the evidence.
Yes.
And second of all, you have to sit down with them and pinpoint exactly what they've done, because they need to accept the fact that it's going to be unilateral, because if they don't accept it, they're going to go to arbitration.
Yes.
And therefore, you have to explain it to them. You might actually have all of the grounds for unilateral termination, but if you say it, if you shout at them, then they're probably not going to accept it.
It's probably going to go very badly for the company. As you mentioned, when emotions get involved, usually it doesn't go well for the company. And I recently got this real case, still ongoing.
Tell me about this case.
Is one employee, the company thinks the employee has seriously breached the company, not only the employee handbook, but also, according to law, is a serious misconduct, asking for kickbacks from a supplier, you would think the company has every right to terminate, to fire this person. And my advice is, okay, you got this email from the supplier claiming that your employee has been asking for kickbacks from the supplier. You think you got the evidence solid, and you go to the employee, shout at him or her, saying that, how could you do this? I've been treating you so well. How can you take money from the company? How can you be so greedy? And you are fired. When you let emotions take over your behavior and taking over your action, what is missing here? The evidence. You are not building the evidence. You are not investigating the evidence. If this evidence is solid, which source did the evidence come from? And do you have supportive evidence to prove that he or she has been really doing this? Because what happened was the company received an email from the supplier saying that the purchasing manager has been asking for kickbacks, has been asking for, okay, where's the money transaction? You don't have any proof. And how did this conversation conducted? It was by face-to-face lunch, when they were having lunch. It was just communicated orally. There's no written, there's no WeChat messages proving that this manager has been asking for money. There's no other evidence. So there's only single witness testimony as the evidence. And this company, the GM got really emotional and asked this purchase manager to leave within 30 minutes. And they just got this arbitration result, very costly.
Yeah. So, I mean, we'll come on to the, a bit of a cliffhanger. We'll come on to the severance payment later.
Yeah.
We'll come back to that example on severance. But one thing that, I want to highlight from that is, it sounds like that the GM, it is emotional that GM, he wanted to end his personal relationship with that employee, and he didn't want to see her again. But the thing is that the employee has a relationship with the company, not with the GM. So if you're making actions on behalf of the company, you need to think from the company's point of view. The company does not have emotions. And labor law does not have emotions either. So you have to tread very carefully, and you have to take the emotions out of the decision and then really look at it from the company's point of view. And that's something that we, as an employer of record, we employ these teams, but that working with our clients, and we try to stay at that kind of that point of view where we take a step back and say, okay, this person's still gonna be employed, they're still operating, and then we're going to take time to understand what's going on and what are the options. I mean, sometimes there are more options than you think, but other times there are less options than you think. And so you need to do that in analysis first before you make any decision.
Exactly. I think not rushing into actions will be the key for every HR manager or the company needs to take into consideration.
Yeah. Okay, I want to go on to another type of unilateral termination around performance. So an employee not performing well. Can you just tell me a bit about the process that a company should go through? Can they unilaterally terminate performance? What would they have to do in order to unilaterally terminate that?
According to the labor contract law, in fact, you can, the company can terminate the agreement unilaterally. However, there are some procedural, as I mentioned, procedural requirements are very important in the whole labor law, labor contract law, and the labor law. What does it mean when someone is non-competent? You need to prove, first of all, you need to prove that this person is not reaching the job description or what kind of KPI that you have set for him or her. Secondly, even if he's not reaching these targets, what kind of actions have you done to either train? Did you have any training for this person, or did you arrange another position for him or her? And only after this, this person still cannot reach the targets. Only after that you can terminate this agreement unilaterally. But still, the company has to pay. It's not.
Yeah. So even if through all of that, the company still has to pay severance.
Yes.
Yeah. Just quickly on that part about arranging another position. What if there is not another position, or what if the position that they change to is of a lower position?
Lower position is okay, but not lower salary.
Right. Okay.
Lower position is okay if you can prove he's really not competent to do this, let's say, manager job, then you can have a different position, but you have to offer the same salary as you agreed in the beginning. Because if you want to change the salary, unless the employee agrees, most of the scenario they wouldn't, then you cannot change the salary. Then it's going to result the high salary for lower position.
Yeah. Which and the thing is that you won't be able to fire them for performance because their requirements are probably lower.
Yes.
So yeah, for example, a manager, you won't be able to fire them for being a poor manager if they're not a manager anymore.
Yes.
So yeah, that is a tricky one. And you would have to offer that before unilaterally terminate.
You cannot directly terminate the contract just because of non-competence. You
But
need
then,
to prove it.
But then would you offer them a different position that they are also not competent in?
After that, you can.
Yeah, so instead of giving them a position where they have like no responsibility, and then you should actually give them a position which is still important.
Yes.
And then see if they can do that. It might be an environment, like maybe it might be the people they're working with. So if you change that, then they still not good. Then you okay. Yeah, that's
yeah. The labor law is in the principle of the labor law is always giving opportunity for the employee to improve or to be employed. So the principle of the labor contract law and labor law is a little, I would say, protective to the employee.
Yeah, very protective.
Yes, very protective.
Yeah, and yeah, that's a lot that we've gone through in many of our episodes. Yeah, it is very protective to the employee. Okay, now we're going to talk about mutually agreed termination. So, earlier we were talking about performance and various things. I reckon a lot of performance-related aspects might be mutually agreed as well. I think a lot of termination in general is actually a mutually agreed process. Okay, let's move on to mutually agreed termination. So, Daisy, why is mutual agreement in termination? Why is this such a common process for termination?
Because this approach is the safest approach for the company to terminate the contract without having the risk of being sued, being filed for arbitration. Because once this agreement has been mutually agreed to terminate, then most of the scenario, the employee cannot go for arbitration anymore. So this is why it's very commonly used, and we always encourage the company, even if you can terminate unilaterally, we still advise you to choose this mutual agreement type to settle this
Yeah, I mean, let's like give the performance as an
Exactly.
example. Um, you could have all of this evidence and you say you're not performing, and we just discussed earlier with the unilateral. You have to change their position. You have to go through all these things to unilaterally terminate, and then still pay severance. So really, the best thing to do is to try and level and try and talk to the employee about this. And again, you still have to collect that evidence of that performance, and then and then essentially try and settle with them.
Yeah, and also I think not only is beneficial for the company, it's also beneficial in some way in the scenario of non-competence. It's also beneficial for the employee, because if you have this mutual agreement with the company, the company will appreciate your cooperation and would probably offer some additional support for your next job. For instance, recommendation letter and some transition days for you to find another job. All this kind of support you can end on a good term with the company, and it's going to be better for the employee as well.
Yeah, and there's usually notice period as well. Yeah, and so let's talk about how do you advise companies to approach this conversation with an employee?
First of all, I would say preparation is key. You don't enter the room without any evidence, without any proof yet. You don't just go there and propose this kind of agreement already, unless you already have all the evidence in place, because you need to have plan A and plan B. If the agreement goes well, then you can terminate by mutual agreement, by mutual consent. If it doesn't go well, you can still choose to unilaterally terminate the agreement. But if you want to do the second way, you need to have all of the evidence in place. Otherwise, it's going to be illegal termination.
So around in preparation, I know that you sit down, you discuss with the employee, you go through. There'll still be grounds for the termination as to why you want to terminate it, with evidence, etc. And then how about the agreement? I mean, does the agreement what does the agreement have to have in place, and what does it not?
In addition to the basic information, for like both parties' information and the reason of the termination, here is important to mention is going to be a mutual agreement initiated by the company. Do not choose the ground that non-performing. This is very important. Don't choose the wrong reason in this agreement.
Yeah.
And secondly, you need to mention the compensation amount, for how long, and also you need to have some unsettled matters like annual leaves. How are you going to settle these annual leaves? If there's any unpaid bonus, if there's any OT still unpaid, all these unsettled matters need to be included. And most important thing is one clause stipulating that the employee is not going to take any legal actions after signing this agreement and receiving all this compensation that has been agreed in this agreement. Because this is the key. This is the whole reason why you are signing this agreement at all.
Yeah, I mean, from our perspective, I mean, we've terminated employees, and actually, not performance related, attitude related, redundancy kind of, not having enough work kind of related, but actually they've all been mutual agreements.
Good.
And because that's the best way to go. It's the most straightforward way. Beforehand, you do the calculation, you prep, you work out how you're going to talk to the employee. Different employees obviously have different personalities, and depending on the reason, some employees might even realize that they're not performing. Some employees might realize that they don't have much work to do. They might realize it's coming. And then you have to have that conversation. And, some employees might not realize at all, but when you tell them that, you're going to give them severance up front without having to fight for it, I think it also works as a very easy matter for the employee as well, because yes, they can go to arbitration and all of that. It's very easy for an employee to do that, but if you're pretty much offering up a decent severance payment, right, in the agreement, in the mutual discussion, then that's it for them. They can get their severance and move on. So what are the kind of like real mistakes that you've seen, companies do during this mutual agreed process?
As I said, I think emotions sometimes take over of the actions. During this conversation, something probably didn't go right, and then the whole procedure will become turned into a unilateral termination. For instance, the GM or the CEO would let this employee leave immediately, and sometimes they were not aware that actually the employee, and sometimes the employee was recording, and the company did not know, because once you enter this room, after a few seconds, the employee comes to realize, okay, what you are going to talk to me is you are trying to force me to leave. So they got this trap that the employee recorded the conversation and then goes home, and the next day, the GM or the CEO regretted for what he did or said, okay, come back to work, let's talk. I did not fire you.
I see. Yeah.
But it's already too late. You had this recording, or some companies even send WeChat messages to the employee. If you don't agree what I offer to you, you don't need to come back to work anymore.
Yeah.
And send this kind of written email or by WeChat messages to the employee.
Yeah.
Then it's already unilaterally termination.
I do have an interesting question. So if you're having this conversation and they don't agree, but then the employee doesn't come back to work the next day on their own instance, and therefore, they're, absent without leave, and, they're not arriving on work. That part is like, how do you, obviously, companies have DACA, stamping in, and they have an attendance policy, but then, but if they don't apply for leave and they just don't rock up to work, obviously it's against the employee handbook, but do you have to write to them to say you've breached the employee handbook? Or
in that scenario, we had a case.
Yeah. Exactly
what happened. As I said, the GM, the CEO of the company, talked to this person in a meeting room, and this employee recorded, said they were trying to reach an agreement and it didn't go well, because actually the company didn't want to pay. They just wanted to sign this agreement but not pay him. Of course, the employee didn't agree, and they didn't finish the meeting in a very happy way. And then the CEO regretted. On the same day, he was not regretting at all. He sent this WeChat message to the employee saying that you don't need to come back to work tomorrow.
Oh, okay, yeah. Well, once he said that
and then the next day, he regretted. So he asked some lawyers, and it was already too late. But of course, we were still trying to fix it. So according to law, actually, only the termination notice in writing is legally binding.
Right, okay.
But in this case, he didn't know there was a recording, of course. But he still sent this WeChat message, and it was a mess. We told him, okay, you can still sign this notice of coming to work. You need to come back to work because we didn't reach an agreement. It's not terminated yet. But the employee, of course, didn't come. Said, "You already told me to go home, not to come back, again. So I see it. You already fired me. I'm not coming back." Even though the company sent written letter to this employee saying that you have to come back to work, otherwise you are breaching this employee handbook, and we are going to have reason to fire you. This employee, of course, went to arbitration. In arbitration, actually, she lost, and all the company, of course, was very happy because according to law, you need written notice, and written notice meaning an official letter from the company. Our conversation wouldn't count.
An email would count.
Yeah, email, yes. And unfortunately, in first instance, the company lost eventually.
In the court.
Yes, in court, company lost. So the lesson learned is before entering any meeting room, you really shouldn't say something like, if you don't agree, you are fired. If you don't agree, you cannot come back anymore. This is seen as you are forcing.
Yeah.
Yes, you are forcing this employee to accept your terms.
Yeah, which isn't a mutually agreed termination.
Not at all.
Yeah.
So mutually agreed only means you are offering some packages and you ask this employee to give them some time to study and to think. And if they agree on site, of course, good. If they don't agree, they need some time to think. Give them some days to think and reflect and consult some lawyers, and then you come back. I wouldn't advise immediate signing this agreement on site, because in some cases, even if you sign this agreement, in legal actions, they were overturned because they thought the court thinks that you were not giving enough time to this employee to think about this offer. So it was kind of forcing them to accept. So
yeah, that's where the grounds between mutually agreed and unilateral become a little bit blurry, actually.
Yes, exactly.
So yeah, like for example, if the court thinks that it's not actually a mutually agreed termination and you're actually forcing them to do it, then
it's illegal.
Then yeah, so it's almost like you should have a process to let them consider it.
Yes.
But one thing, like my question was like, if they go away and they think about it, but then they don't turn up to work the next day, then yeah.
If you didn't tell them they don't need to come back to work, then of course it's a breach of the employee handbook.
Yeah.
Then you need to send. Usually what we advise the company to do is you still send notice to the employee.
You just send the notice, go through your standard process.
Yes.
Yes. Right. So that's mutually agreed. I mean, it covers all manner of sins, all manner of discrepancies and issues. But it was also the most common, the most straightforward approach, and almost always includes severance. So right, next on we'll start talking about severance. So we were talking about emotions and the story about someone sending the messages, but it was already too late because they'd already sent out something. How many of the clients come to you before it's too late, and how many of them come for advice on how to handle it?
There are two types of the clients. One is when they have either a very strong HR team internally, or they have us or external legal counsel already in retainer. This type of clients, they would consult us, or they would have very thorough procedure discussed with the HR team before they do anything. So these type of clients are usually very, they don't make mistakes. They always play by the book. But the other type, I would say 50-50. If the client comes to me telling me this, usually it's already too late.
Right.
when they come to us, oh, I did this and I did that, I lost this arbitration, what can we do now? Unfortunately, it's already too late. Not much that you can do to overturn this result. The damage has been done.
And the latter part, what type of companies would that be? Like,
usually small companies.
Yeah, small companies.
Small companies, they have smaller budget. They don't want to have this external fee for annual retainer or have external HR consulting companies.
Yeah. So that's what's really important, especially if you hire boots on the ground, teams on the ground, is to what extent do you need that HR support? Every company needs it. As soon as they employ someone and have an employee handbook, that everyone needs a custodian, someone to really follow the employee handbook and follow up onto that. Not saying that everyone needs a lawyer, an internal lawyer, or even external, on retainer, but they definitely need someone to follow the procedure step by step. And that's what I think a lot of our clients need to really understand.
Yes.
So let's move on to severance. Okay, so severance, and this can be for almost all types of termination. Well, where should we start? I mean, I think the magical N, the letter N, or the number, letter and number. Can you give me an overview of how severance is calculated?
So, as you mentioned, there's a magic word, N, letter N. In Chinese labor law, this is the fundamental calculation for all types of compensation. N represents the service year, the total service year of the employee has been working for the company. Each year constitutes as 1 month of salary. So, for instance, if the employee has been working for this company for 10 years, let's say 9 years and 10 months, then N is 10. N equals 10. And the severance will be, if it's N, it's going to be 10 months of the average salary of this employee. If it's less than 6 months, then N is 0.5, is half month. If it's more than 6 months, less than 1 year, then it counts for 1. So if it's 9 years and 10 months, N is 10.
10,
yes, rather than 9.
Yeah, there was a case that we had with a client where the issues were happening within the first year, so around maybe 11 months. But we thought they would be resolved, but they weren't, and then it went to 1 year and 1 year and 1 month, and the same issue. But then in the end, we discussed with them to go. But that sort of delay there meant that we had to pay 1.5. N was 1.5 because it's just gone over that 1 year anniversary. As soon a day over 1 year anniversary, it's 1.5. So, like you said, 9 years, 10 months is 10. N is 10. And what about N+1? In what scenarios do you have to give notice?
I think this is the commonly misunderstood point for companies. Not only foreign companies, but also Chinese companies are always misunderstanding this N+1. They always think N is associated with this 1 month notice or 1 month payment in lieu of notice. In fact, only one scenario would trigger this +1, which is according to Article 40 of Labor Contract Law, when is we call it non-fault termination, unilaterally termination by the employee. By the employer. As we said, this non-performing is falling under this scenario, and also the after medical period has been after the medical period, this employee can still not return back to work. This is also another scenario. And the other one is the major circumstances change that this contract cannot be performed anymore. We call this non-fault termination by the employer, by the company. Only this scenario triggers +1.
Okay, so let's. It's only in those circumstances that you need to give
30 days
30 days notice, even for a mutually agreed.
Mutually agreed you don't need to give 30 days
Okay.
payment in lieu.
Okay,
Only N.
Yeah, and only if there's a non-fault unilateral.
Yes.
So that's not so that the performance is included in that.
Yeah.
You'd have to give +1.
Yes.
The medical period, after the medical period they come back, you have to give +1.
Yes.
And major circumstances in which they can't perform it, say, we won't go into that too many examples. But yeah, so in every other case you don't have to give +1. That you don't have to give notice. I mean, of course.
No.
Yeah. But then again, most of the time when we're doing N, it's a mutually agreed, and some notice. It's not necessary, but
it's nice to give.
But it might help them accept it.
Exactly. By law, you don't need to give this period of notice. However, in reality, we always advise the clients to give +1 as a gesture, as a nice gesture, to show good faith. Because if you want to choose this mutual agreement, you need to win this employee to see that you are really not trying to trick him, not trying to fault him. You are trying to help him or her. It's only under only unwillingly that you are terminating this agreement mutually with him or her. So it'd be nice for the company to offer 1 month plus. It doesn't have to be 1 month.
It doesn't have
exact.
to be 1 month, but some
notice. Yes, maybe half month salary offering. Sometimes even some companies offer 3 months, 2 months. It's up to the company. But the bottom line is N when you are choosing this mutual agreement.
Yeah, and that just reminded me about that notice period. Is at the beginning we talked about automatic expiry, so non-renewal of contract.
Yes.
Your companies still have to pay severance. Is that correct?
Yes, correct. That's a misunderstanding also for some companies. They think if the company has expired, why do I have to pay?
Yeah. So let's make that one crystal clear. Even if the contract comes to the end and you decide not to renew it, for whatever reason, if you think that that's a sneaky way out of not paying any severance by waiting until the expiry of the contract, that is not the case. It's still very much N. And correct me if I'm wrong, you also still need to give prior warning that you're not going to renew it. Is that correct?
This is depending on the city. In some cities, they require this 1 month, also 30 days prior notice. You need to, let's say if the contract is ending on December 31st, you need to issue this notice to the employee that you need 1 month prior. You are not renewing this agreement when the agreement expires. But in some cities, they don't need to have this prior notice. So you need to really check the local practice before you do this. But to be safe, on the safe side, always have this calendar.
Notice,
always have this reminder before 30 days and you make the decision.
Yeah, I mean, that's what we do. I mean, we employ people in 7 different cities in China, and we have entities in all these different cities. I'll be frank, we just assume that it's 30 days notice.
It's good.
Because we don't want to force any mistakes. So, that's absolutely key. I mean, even if you're going to renew, I mean, when we're talking with our clients, we always want to get them to signal, that everything's happy, try and have an annual review and, get them to, choose to renew or not. But it's a very, it's important to keep track of it. Absolutely. And of course, let's talk about 2N. how about, you mentioned earlier about a case with the purchasing manager and being accused of taking kickbacks or asking for kickbacks.
Exactly.
And the employer, the GM, went for unilateral termination, and you said that they lost, right?
Yes.
So they lost. The employee won, and it was illegal termination.
Exactly.
Okay, so tell me about the severance for that.
So in this case, the purchasing manager had been working for the company for 13 years.
13 years.
13 years, yeah, it's a long-term employee. And her salary was 19,000 per month before she was terminated. So the severance pay, if it was legal, of course, if it was legal, they didn't need to pay at all because it was misconduct, right?
Because of gross misconduct.
But because they lost the case in arbitration, the ultimate ruling was 2N. 2N means 19,000 for 13 years and times 2.
Yeah.
So at the end, the total compensation would be more than 500,000.
500,000. I think maybe we'll ask Jay to get some. Maybe we'll do some graphics on the calculations. Put it on there. So 19,000 salary, 13 years. So N is 13 times 2. Yeah, So and it could have been 0. But actually, just going back to that point, I know it's not severance related, but the accusation was that she asked for bribes. So they've heard the bribes, and
it's hard to prove.
It's hard to prove. And how do you continue working? How would you advise someone to continue working with someone when there's these accusations? I guess you have to do an investigation, right?
Yes, exactly.
And you can obviously, if they've been accused of that, the factory's asked them, you do the investigation, and the company is allowed to do an investigation.
Yes.
Within reason, and just say, look, we've received this. We have to do an investigation, right? No matter, that might result in a little bit of breakdown in trust, but would that be the right thing to do? Because you can't just ignore it. Right?
You cannot ignore it. There are 2 things that you need to do. First is to collect evidence. And once you collect all the evidence, you still need to have this interview, and you need to give the employee the right to defend herself. Because this is a very serious accusation. You cannot just listen to one supplier's hearsay. It's hearsay. There's no actual evidence proving there had been some transaction between this supplier and this employee.
Yeah.
So number 1 is collection of evidence, and number 2 is also you need to give the employee the right to defend. So these are the 2 serious missteps by the company. That's why
these are the things that you would have advised them had they asked you beforehand.
Before talking to her, you need to have the evidence already.
Yeah.
The thing is, I think they probably had this misunderstanding of trusting this evidence was already enough, but it was not.
Yeah.
It was only 1 email from a supplier saying that she was asking for kickbacks.
And also, you give them the right to defend, and it might actually be the case that they can't defend themselves, and they might resign.
Exactly.
And
that was the approach.
We've not the same thing, but I one case where it was a bit of performance, a bit of lack of lack of trust. We didn't exactly do an investigation, but we put some more closer eyes on the way that someone was working, and they just resigned in the end. And I think if it is true, it would come out. And I think a lot, I think I don't know if it's a Chinese thing, but I think most employees would have that a level of shame if they feel like they're guilty in something, and then maybe there's only a matter of time before they get found out. So
Yes.
yeah, and yeah, again, if they did find out, it's gross misconduct. I mean, they asked for it, but if they'd actually taken bribes, actually had taken kickbacks and received it beyond the actual kick, what is the employee liable for in that case?
You mean for criminal consequences?
Financial, or if they'd taken kickbacks against the from the supplier.
If there was actual transaction, there are a few layers of consequences. Number one, of course, the company has the right to dismiss, to fire her or him immediately. Second is if there's losses for the company can claim damages from the employee. Thirdly, also there might be criminal consequences depending on the total amount. But most of the companies would not go for the third one. No.
Yeah.
This is usually the approach that I would suggest is, as you said, you collect the evidence and you have this pressure to this employee and ask them to resign to save his or her face and also save the company's face, also the supplier's face.
Yeah. Yeah.
So that you reach this agreement and you just close this chapter.
Yeah.
Just move on.
Yeah, and move on. That's the most important thing. But the key thing is to know is, from an employment relationship, the employee is liable. They're liable for the money they took.
Yes.
Obviously, they can be fired, and they could be criminally liable as well. And the point is more of like a deterrent than anything else. Is like they are liable for it. Yeah. So a company could pursue them for it, even though maybe it's probably best just to move on.
Yeah, I had another. It was not my case, but yesterday I just got this. I was having a conversation with my colleague. He just took a similar case. Also, a supplier gave some gifts to the company, to the client. But the purchasing manager took the gifts without telling the company, and sold it. And it was Maotai.
Not high. Maotai. Right. Okay.
Many boxes of Maotai.
Yeah.
Worth 3 million.
Famous rice wine. For anyone who doesn't know.
Yeah.
3 million RMB.
Yes, and I think he sold it for 1 million. Of course, when you are selling this kind of.
Yeah, you're not going to sell it.
You sell at exactly. So the company came to my colleague and asked him for opinion. So there were two options. You can go. Definitely 3 million is already definitely criminal case. You can go for it, or you can just get back the money and just move on.
Yeah.
And this company chose to go for criminal.
Really?
They filed the report to
but
the
even
police.
if, these were gifts from a supplier, so they got the gifts, which was for the company.
Yes. It's illegal to give rebate to the company, but it's illegal to give to individuals.
Yeah. Yeah. So they gave the Maotai as a rebate. So it was
as a gift to the supplier. Yeah. Because they were giving this to all the clients.
Yeah. But the client pursued it, even though they didn't lose 3 million because it's a gift, right? I guess they gave that gift and then they. Yeah, they lost 3 million of assets, right? Because that's an interesting case. Yeah, yeah.
So,
but no 2N involved in that one, I guess. But okay. So another part is about the cap. There are limits in severance, right? So tell me about the limits.
So the cap, there are two layers. The fundamental cap is relating to the monthly salary of the employee. If it is over 3 times of the average salary of the municipal level of where the employer is based. So for instance, I think in Shenzhen now the average salary is almost is around 14,000 per month. So 3 times is 42,000 per month. If the employee's salary is, let's say, 50,000, then it's already reached the cap of 3 times of the average salary. So when you're calculating N, the N is capped at 42,000.
Right. Yeah. So let's say we had someone in a city where the average salary was 10,000. Their salary is 35,000. Or actually, if you include bonuses and all that, the average salary closer to 40,000. And let's say they were working for 5 years, you would use, so it's 10 in that city, so it's 30,000 times 5.
Yes.
And that would be N.
Yes.
Wouldn't it? As opposed to 40.
This is the layer 1. The other layer is about the total years of service.
Yeah.
There's also a cap, but only the second cap is only applicable when the salary is more than 3 times. Let's use your example. If this employee has been working for the company for 15 years, and his salary is 35 or 40,000 per month, but the cap is 30,000, right? So his compensation, if it's N, is going to be calculated as 30,000 times 12 rather than 35 times 15.
Yeah. Okay.
So there are 2 caps.
So he would have 2 caps on that. Yeah.
Yes.
So it's capped at 12 years. So, really that's 30,000 times 12. Yeah. So that's so the cap in that city is 360,000.
Yes.
Yeah.
And if the employee's salary is 29,000, not 30,000, then it's going to be 29,000 times 15, not 12 anymore.
Yeah, that's
so it's
tricky.
Depending on the fundamental criteria we refer to is the monthly salary.
Yeah, that's interesting. I think we're gonna write an article and pinpoint the average salaries in every single city, because that's salary. Especially for some of these high tech jobs, salaries are high.
Yes.
In Shenzhen, you can. We haven't got anyone that high, but it is high. Yeah. I mean,
we got another case. The salary was 85,000 per month, and
85.
Yeah, adding all this bonus and other allowances, monthly 100,000, more than 100,000 per month. But the cap is only in Foshan, around 28,000.
It's 28,000.
Yeah.
That's interesting. Yeah. So and another part of this severance and when terminating contract, and it's a sneaky part that I really want to ask you about, is about unpaid leave.
Oh, yes.
And how to calculate that as part of a severance package, because I think that is the sting in the tail that companies do not pay enough attention to. So let's say, because actually I just give a brief overview of this. For us, with some of the work, the employees, they're very hardworking, and it's not like they take too much holiday. They don't take enough holiday. They work, they do. They're just very hardworking, and then you get to the end of the year and they haven't taken their annual leave for the previous year, and it's like, you've got to take it, and we make plans for them to take it. But if they decide to leave or they're terminated, how is that calculated? What happens to that holiday?
So this is also another tricky one that also always cause for dispute between the company and the employee. What I advise is you always need to prepare in advance, not on the day of the termination, because then it's going to be too late. What's usually the tricky one is number one, they didn't use the unpaid leave within this period of within this year, and some companies allow the employees to use probably extend this term to maybe 3 months usually after Chinese New Year. This is allowed. However, you need to get written consent from the employee, or you need to get the application from the employee.
To ask for it.
Yeah, either they ask for it, or you get their signature that they have agreed to use this after the Chinese New Year. So this is number one that you need to, before even terminating or not terminating for every employee, you need to have this sense. If they cannot finish this annual leave in this 1 year, you can extend, but with written consent from the employee. This is number one. Number two is, if they cannot finish, even after this extension, you need to ask them to take anyways.
Yeah.
With their agreement or not, you need to plan.
You make a plan. Yeah.
You need to make this plan and force them to take. Because otherwise, on the day of the termination, the unpaid annual leave can be very expensive. It's 3 times of the daily salary.
Yeah, so unpaid annual leave 3 times. Yes. Overtime 2 times. Is that correct?
Overtime is for weekend 2 times, for
national
daily
holiday. Yeah. Or daily, like hourly, like
daily extension of working hours is 1.5.
1.5.
Weekend is 2 times. And for the public holidays, 3 times. And also for the unused annual leave is also 3 times.
Yeah. A question about getting their written consent. Do you have to get that from the employee, or can you get it from their line manager? Does it have to be from
personal?
It has to be personal.
Yes.
Yeah.
Because the line manager cannot represent the employee's will. So it has to be signed by the employee.
Yeah. So, this is one of the, key aspects of ongoing HR management is actually counting their leave and counting which days are they working, which days are they not working, which days are they actually building up overtime. It has to be counted because I can guarantee that the employee is counting.
Yes, definitely.
Even if they don't say it and everyone's happy, they're definitely counting it.
Yes.
And that is, that is where a lot of companies, even when they resign, it might not even be a termination, a really bad thing. Yes, they resign. Okay, great, but there can just be a few thousand or tens of thousands. It could be tens of thousands. Yes. Of just leave that they haven't taken, and proper planning throughout the year, and then also especially at termination, is so important for it will save a lot of money.
Yes. So what I would advise is, if you are choosing this mutual agreement type of termination, before you talk to this person or during this negotiation phase, you have these days ready, and you arrange these days before the termination date. For instance, if you are going to terminate, you are entering this negotiation with the employee on January 1st, and this person still has last year's probably 10 days unused, you would enter this negotiation and having this clear 10 days on your mind, and then arrange before the termination date. For instance, if you agree to terminate on January 31st, you have, from January 10th to January 30th, you have to take these days off. And I give you these days. You don't need to come back to work. You just need to do the handover from January 1st to January 9th. And all the rest days are your unused annual leaves.
You take it. It's paid leave.
Before this termination date.
Yeah.
Then you have this already used. Then they cannot claim for.
I had a question about that. Let's say, is there any? I mean, if the whole thing is, the relationship is not good, is there any risk of the fact that that employee is still employed, but they are on holiday? and you have that termination meeting, and you get the acceptance, and this is the last day, and then you plan the holiday. Is there anything like, could the employee, is there anything like, if they get injured, for example, even though they're on holiday,
Yeah. So until the termination date, all the rights and benefits of the employee is still
there,
covered.
Yeah.
Yes.
So,
but on holidays, the work injury will be different. Work injury has to be you are rendering work to the company will be, and you get injured, then that's work injury. But if you get injured outside of the work context on holiday, let's say if you are traveling in some cities and then you got car accident, that's not work injury.
But if they're still employed, but they've signed the termination agreement, there's not going to be a medical treatment period, right?
That's going to be the tricky one. You probably will be unable to do it, because,
even though they've signed the termination agreement.
Yeah.
So this is what I thought. I mean, the best case scenario is to plan their annual leave so that it's relatively low. So they don't have, or also their overtime. So they don't have like 30 days overtime or something ridiculous like that. You have to keep it within a certain lower number, so that when it comes to termination, maybe just pay it. If it's like 1 or 2 days annual leave left, just pay it. Yeah. Because if something happens to them during that time, very unlikely, but that's going to be more tricky. Just the legal advice itself is probably going to cost way more than the holiday. So
exactly.
Yeah.
So depending on the salary.
Yeah, depending on the salary, the person, depending on the company as well. But I mean, in the past, if there's been holiday, we've some of our depending on the salary, but we've just paid the the additional holiday just to for peace of mind. Yeah. It also depends on how the conversation goes.
Yeah, because then you have the advantage. You can terminate immediately. You don't need to. This person doesn't need to come back for another 10 or 15 days. You can just terminate already.
Yeah.
And this is buying exactly the peace of mind.
Yeah.
If you choose to arrange these days before the termination date, then you need to take a risk. If something happens during this date, then you cannot terminate anymore. So this is a balance that you need to find.
Okay, so I think, Daisy, we're going to wrap it up there. We've talked all types of termination. I hope everyone there at home has found it interesting. Please like and subscribe. To follow more. We've got some fantastic episodes coming up, and please also check all of our previous episodes and delve through this one. But before we go, I mean, what sort of practical tips would you give to foreign companies about termination?
So I would give, let's say, 3 tips. Number 1 is documentation.
Yeah.
99% you are going to lose any arbitration or court. So record everything in writing and have all this documentation in place before you actually do anything. Number 2 is procedural requirements. Always have this mindset that everything you need to follow a certain procedure according to Chinese labor law. Number 3 is the employee handbook. Employee handbook is part of the documentation. It's also part of the procedural requirements, and I cannot emphasize enough how important employee handbook it is for all this, regardless where you are from, Chinese company, foreign company, you all have to have this employee handbook. And employee handbook, when you are smaller, it's even easier to have it legally valid. Once you're a big company, it's very difficult to meet all these procedural requirements. So documentation, procedural requirements, and also employee handbook are very important.
Yeah, so like you say, documentation. You've got the evidence, which is documentation. You've got the procedure, which is documentation, and you've got the employee handbook, which is one big fat document.
Yes.
So yeah, no, thank you. That's great. And the mindset of approaching it as well. Can you tell me how would you advise foreign companies to approach it? How would they mentally approach termination?
So when you want to terminate the contract, always try to use this mutual termination approach, because it's the safest. It's going to save both the employee and the employer's faces, and is usually easier for the employee to accept. And always entering this negotiation room, or always entering this conversation with enough evidence, whatever grounds that you are using, having enough evidence, and having a let's say, cooperative mindset with the employee. Show your good faith, and always forget about not paying anything. Always try to have this openness to compensation, even if it's N or N+1. Have a reasonable package offered to the employee. Usually it's easier to reach an agreement.
Yeah, absolutely. Yeah, I concur. Forget about not paying severance. Just assume you have to pay it. Come find us to work out how much you have to pay. If you don't have to pay it, then happy days, surprise. But don't assume that in the first instance. So I'd like to say thank you very much, Daisy, for coming. And thank you for watching. Make sure you tune in. My name's Benjamin King, here with Daisy Yang. See you next time.
Thank you.